Good day, ladies and gentlemen. Joy Stephen from the Polinsys Studios, and here is another case law for the Student Herald. Sau versus Canada. Case laws are not meant for people interested to apply for permanent residence in Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog reportersreport.com as a PDF document. This case is an immigration case about refugee status and covers topics like requirements, identity. Refugee claimant alleged that she was citizen of Mauritania. In hearing before Refugee Protection Division (RPD), claimant produced single identity document in form of photocopy of birth certificate. RPD was not satisfied with claimant's explanation for failing to produce original birth certificate or additional reliable identity documentation. RPD was also concerned by claimant's inability to answer basic questions about her life in Mauritania. RPD concluded the claimant had not established her personal or national identity and had not made reasonable attempts to do so. RPD also drew significant negative credibility inference from claimant's testimony in support of her identity and nationality. Claimant appealed RPD findings to Refugee Appeals Division or the RAD, where she sought to strengthen her claim with email evidence about her subsequent but failed efforts to obtain better identity documents. RAD refused to admit any of newly adducted evidence on basis that it neither did not comply with admissibility criteria as in S-110-4 or of Immigration and Refugee Protection Act of Canada, or was irrelevant. In its decision, RAD stated that email documents were not evidence that arose after rejection of claim, and then stated that some documents did arise after rejection of claim, thus contradicting itself. Claimant applied for judicial review, application was granted, matter remitted for reconsideration on merits of different decision maker. RAD's rejection of at least some of evidence rendered on behalf of claimant was unreasonable. Section 110(4) of Act must be applied to RAD with degree of flexibility commensurate with surrounding circumstance. While emails did not more than establish failed attempts by counsel to obtain better identity documentations, emails were not irrelevant. Section 106 of Act states that evidence bearing on unsuccessful steps taken to obtain identity documents is relevant and may overcome concerns about adequacy of what was produced. This appears to be recognition that in some parts of the world, cognate identity documentation may be difficult, if not impossible, to obtain, and legitimate refugee claimants ought not to be prejudiced by that fact alone. While more could have been done to attempt to overcome identity concerns of RPD and RAD, this did not displace obligation of RAD to apply required standard of review to evidence or to reasonably accept and access evidence put to it. Sau versus Canada, very interesting case for the refugee aspect, dated March 9th, 2015 from the Federal Court. Adios. Thank you.